Thanks for staying with us. You're still watching the AM show. Now, let's talk about something that I guess we would get a lot more clarity by close of court day today. There's a big question. Is the Member of Parliament for Boko, Mahama Ayariga, going to go to court today? Would he be in the High Court today? We wait to see. We have a conversation on this, but before that, I want to run you through how we have come so far with this issue with the special prosecutor and the Member of Parliament for Boko, Mahama Ayariga. And quickly just taking you through with the information that I have in terms of the trial. That's how we choose to name it. It's a trial of Boko Central NP. And we're not doing the response now. Let's go back to how it all started. We go back to how it all started. We'll take a quick break. I'll come back and then we'll get this conversation going. All right, so let's get this conversation going now. Where have we come from with this whole issue of the special prosecutor and Mahama Ayariga is the trial of the Boko Central Member of Parliament? Now, after undertaking preliminary investigations into the suspected commission of corruption and corruption-related offences, including the abuse of public office for private gain, the special prosecutor decided that there is sufficient grounds to invite Mahama Ayariga for the conduct of full investigations into the allegations. We'll get into the matter of exactly what he has done or is supposed to have done, allegedly done. But this is where we have come from. The preliminary investigations pertain to the importation into Ghana through corrupt means and corruption-related activities of 3 used white Toyota Land Cruiser V8 vehicles by using a parliamentary resolution dated 7th April 2017. Now, if we move on, at the time, the special prosecutor had said because the investigations division of his office was in the process of being set up, he asked the Economic and Organized Crime Office to undertake a joint investigation of the suspected offenses with his office. Okay, so the special prosecutor asked the speaker to release the suspect, and that's how he termed it. If you look at his communication, even with the Speaker of Parliament, the suspect to report to Iyoko on the 3rd of July, 2018. And there is a little matter in there because Mahama Ayariga challenged the special prosecutor on this. There was an issue with allowing the special prosecutor to go through his communication with the telecoms operator, the specific one that Mr. Mahama Ayariga uses, which, if you remember, he wrote a letter and said that if you give my personal information to the special prosecutor, I'm going to deal with you. That matter has actually, where are we with that matter? We actually are not clear. We don't even know if the special prosecutor went ahead to get personal telecommunication information from MTN, if you like. But let's move on with where the matter has progressed to. It was after this that the special prosecutor said Mahama Ayariga got people such as personal friends, you remember, former colleagues, chiefs, men of God, etc., to abate the investigations. He therefore asked Iyoko to warn Mr. Ayariga to desist from his conduct of obstructing the investigations by soliciting others to put pressure on the special prosecutor. So what is the charge exactly? Here's the charge: 4 counts of fraudulent evasion of customs duties and taxes, using public office for private benefit, dealing in foreign exchange without license, and transfer of foreign exchange from Ghana through an unauthorized dealer. I must say, by the way, that Mr. Mahama Ayariga denies all these charges. The special prosecutor sent a letter to the Speaker of Parliament requesting that Mr. Ayariga be released for arraignment in court. There's an issue. If it is a court that is asking you to present yourself to it, must the special prosecutor write a letter to the Speaker asking for Mr. Ayariga to be released so that he can go to court? The court date is today, by the way. Here's Ms. Ayariga's response. Ms. Ayariga contends that the Speaker was not vested with the powers to release a sitting member of Parliament from sittings. In a letter addressed to the Special Prosecutor dated June 2, Ms. Ayariga said he cannot honor the Tuesday, June 4 summons and can only be present in court on any other day that does not coincide with parliamentary sittings. All right, so this is how far we have come. June 4 is today. Will Mr. Mahama Ayariga, the Boko Central Member of Parliament, go to Parliament or not? The last time we checked with him, which was yesterday, he was still standing by his words, but he slept over those words. So will something change this morning? I believe my guest is a very good friend of Mr. Ayariga, and he will tell us if there's something new with that. But I've got to say, Kolafia to Alaji. Good morning to you.
Good morning. How are you?
Fine, thank you. Thank you for making it into the studio.
Thank you so very much.
Yeah.
And let me take opportunity to wish my Muslim brothers and sisters Eid al-Mubarak. Kullu sana wa antum bi khair. Yesterday, the moon was sighted in some parts of the world.
Okay.
So Saudi Arabia is praying today. Some parts of Ghana are praying today. Some people in Accra are praying today.
Okay.
Some people in my constituency, Tamil, are praying today. Others did not see the moon. They have to wait till tomorrow. And so it's only appropriate that I use your platform to wish all my Muslim brothers and sisters Eid al-Mubarak.
Alaji, did you see the moon?
Well, I am a Muslim who believes and follows my elders, my leaders.
Okay.
And when they say they have seen the moon, I have every reason to believe that they have.
All right. So let me say Baraka the Sanla then.
Baraka kede ale bibi tamuna. Ale bibi tamuna.
Okay. Innocent Fuseni is Member of Parliament for Tamale Central. He is also a private legal practitioner. We're going to be exploring this issue further. And I'm just the fascination of the immunities that members of Parliament enjoy. Give us a bit of clarity from where you sit. I am a bit confused about the special prosecutor writing to the Speaker and asking for Mr. Mahama Ayariga to be released. If it's a court that summoned you, what has the special prosecutor got to do with the process, the court process? I thought the court serves you.
Yeah, thank you so very much. First of all, you need to understand the regime of immunities and privileges given to members of Parliament to be able to conduct their duties as members of Parliament. These immunities, I must confess, are not absolute. And so they can be, they're subject to certain procedures and regulations. And that being so, they are intended to ensure that members of Parliament are able to perform their duties effectively and efficiently. For instance, while on the floor of the House, a member of Parliament cannot be cited for defamation or libel for matters spoken on the floor of the House. If it's outside the House, like I'm sitting at the in your studio, if I offer or utter defamatory words which impugn the integrity of another person, I might be liable to. And so that is why I say the immunities are not absolute.
But you can't cite the fact that you're on your way to Parliament?
No, but I'm sitting here. I am on my way to Parliament. Okay?
Yeah.
And so while on my way to Parliament, I cannot be served with the process. Okay? And no, the Speaker cannot compel me no process can compel the Speaker or me to appear in court as a witness. No process. Now, they can file a process in court subpoenaing me to appear, compelling me to appear as a witness in court. The Constitution is very absolute, and that's an absolute, prohibition on any process that seeks to compel the member of Parliament to come to court. And so, as a witness. Now, back to Ayariga.
Yeah. Oh, so can I follow up with as a witness?
As a witness, yes.
Okay, but doesn't that applies to ordinary Ghanaians as well, right? You can't compel me to come.
You can subpoena a person to come to court.
Okay, but you can't do that to the
member
MP.
of Parliament.
Okay.
Yes, you can do that. Now, so back to Ayariga. So all this matter about Ayariga are matters that clearly raises very interesting legal issues. even the charge itself raises legal issues. I mean, jurisprudential, serious jurisprudential issues. At what point will a person who takes a loan for the purposes of securing a vehicle for the conduct of his public duties be subject to regulations on how to use the vehicle?
What are the terms for taking the loan as MPs?
We should not.
Do they ask you?
I'm going to resist the temptation to go into the merits of this case.
No, we're not going into the merits. You are also a member of parliament. You are not Mahama Ayariga. You are Inusa Fuseni. You also took the loan. I'm asking you an open question.
I'm just saying that, well, let's resist the temptation to go to the merits.
No,
these matters will go to the defense
so
of the matter.
I'm just asking, this matter has not even gone to court yet. So there's no temptation.
It's in court.
Mr. Mahama Ayariga, has it been to court?
Oh, the matter is in court. The matter has been filed. The process has been filed, inviting, summoning Mahama Ayariga to appear before a judge in the High Court, Criminal Division of the High Court in Accra today. Now,
but this has to do with him. So I'm asking a general question of the terms and conditions of the loan given to members of parliament.
The terms of loan and conditions of the loan given to members of parliament,
yes, sir, including
Mahama Ayariga, is to buy a vehicle. Okay, is to buy a vehicle.
Are there specifications
of vehicles?
Yes.
No.
Okay.
Now you see that there are no specifications. That's why when you go to parliament, you see people with saloon cars, you see people with 4x4 and different pickups and whatnot. There are no specifications.
But are you supposed to buy one vehicle only, or you can choose to buy whatever you want to buy?
Again, it goes to the arrangement. So when we started, when I came to parliament, it was just one vehicle. I think many people at that time, I just knew of Japan Motors then. I mean, you wanted a vehicle, they came around, and then they showed you the catalog and you chose, and then they went engaged parliament, and then you access your vehicle. That's how I got my vehicle.
Okay.
The second time I was taking a vehicle, then the Ibrahim Muhammad's company came along, Stalin.
Okay.
So I bought from him.
Okay.
Okay. I just feel, I said I needed this particular type of vehicle, and he followed up and took the resources and everything, and delivered the vehicle to me. That's
okay.
All. Now, and the third time, no, an MP told me, no, you know what? You can always buy the vehicle of your choice. So you don't need to. So I can help you to get a Benz car, okay, at the same loan. And so I said, okay, fine. Then so his company imported a Benz vehicle and took the money.
Was it brand new?
Was not totally brand new.
Okay.
Okay. Now, so and took the money. So this is how. And then when they take them, when the vehicle comes in, or when the loan is approved by Parliament, deductions are made. Okay, to amortize the loan over a period of 4 years. In the event that you are unable to amortize the loan by the deductions, your end of service benefits is used to secure the remainder of the outstanding amount to be paid. Now, we are Parliament. We approve waivers, tax waivers for companies. We approve tax waivers for doctors who want to take their vehicles. We approve waivers for diplomats who are coming back to this country with vehicles. To clear their vehicles without paying tax because of the services they are provided for this country outside. So we also approve waivers for members of Parliament to take those vehicles to perform public duties. Now, so when you take when you import the vehicle beyond a certain threshold, I just told you I bought a Benz car. So when my Benz car came, they told me the threshold was beyond the allowable tax exemption. Okay. So I had to pay extra.
Okay.
Okay. So that's what happened. So.
Oh, you didn't have to pay extra. You just had to pay the excess.
No, the excess of the tax waiver.
Yes.
Yes, the excess of the tax waiver. So I did that. And now, companies come to Parliament and they tell you, okay, you see, you are given this amount of money. And we have got these vehicles that we can combine and give it to you at the same amount to go for the same tax waiver. Okay? Now you want an iPhone, what, X Max.
No, you haven't bought me an iPhone yet.
No, I know.
Okay.
You want an iPhone X Max. And I've got an iPhone 6 max a mini, or iPhone 8 max a mini.
I have no idea these types of phones.
So then I say, okay, if you want the iPhone X Max, this is how it costs. Now, I can give you 2 iPhones for you and your husband, a mini and a max, but it will be iPhone 8 at the same cost. You pay the same VAT on it. Now, it's left to you to decide whether you need the 2 vehicles for the 2 different purposes. But it will be cleared on the same tax waiver. So I know members of parliament who have gone for 2 vehicles and they've used the same tax waiver to clear. And so now, so this is how the loan is organized. It's a loan approved by Parliament, secured from SSB, Societe Generale, SG, SSB.
SGS, yeah.
And then entitles a member of Parliament to a certain amount of money. That amount of money will be amortized over a period of 4 years, where a member of Parliament has commitments beyond his salary. His end of service benefits will be used to secure the remainder of the payment of the loan. The member of Parliament is entitled to a waiver of the tax on the purchase of the vehicle. And so these are the general terms of the loan. And the loan is guaranteed. Payment is guaranteed by government. Government will issue a letter of comfort to say that this member of Parliament is a member of Parliament and he's entitled to salary. And his salary, part of his salary, will be deducted as source for the purposes of amortizing the loan. And so that's the letter of comfort. So what are the facts of the case? The facts of the case speak to a situation in which Honorable Ayariga accessed the loan and then decided that it was more beneficial to him to access 3 vehicles from the loan, slightly used vehicles from Dubai on the loan. He contracted a dealer and gave the dealer's name up for the purpose of accessing the money from Parliament. The dealer was able to do that, and the vehicles came. Now, because there were 3 vehicles, he was charged extra above. I mean, the duty he was to pay was above the loan that was.
So just like in your case.
Just like
in your personal case.
Now, so he paid and cleared the vehicles. He paid the excess.
Is it that simple? Like the way, did it follow that process?
I have no reason to believe that I didn't follow that process, because we are all men of the world, not so. You are a woman of the world. I don't know whether you've ever imported a vehicle.
No, I haven't.
Now, when you do import a vehicle, you will have no locus, no capacity to clear the vehicle at the port.
You need an agent.
You need an agent. Some of the agents are sufficiently resourced, so they clear everything and charge you. They say, look, this was the tax that I paid on it. They show you my commission is so and so, and then you pay them and take your vehicle. Now, if the agent is not sufficiently resourced, he comes to you and says that, well, the tax on the vehicle that you have imported has been assessed at this amount, and then you pay. You give him the amount, he goes to pay.
So which one would fit Mahama Ayariga's scenario?
Both will fit Mahama Ayariga's scenario in the sense that Mahama Ayariga cannot present himself at the tax clearing agency to clear his vehicle because he has no capacity.
So he did it.
So someone cleared it. Now NEPL paid. So when I read the charge sheet, I hear that the tax was assessed at 36.
So lower than it should have been.
No, well, I'm not getting even that impression. The tax was assessed as 36,000 Ghana cedis, and then he paid 6,000. Mahama Ayariga paid 6,000. Then the question is, did Mahama Ayariga pay 6,000?
Did he?
Or the agent paid 6,000?
Did they?
No, I'm just asking. So if the agent paid 6,000, who received the payment? Was it pursuant to official documents evidencing the amount to be paid, or was it discretionary?
You should tell us.
No, I don't know. These are the questions. That's why I'm saying that this matter raises interesting legal matters, and not even go into the the substance of the matter. And I understand that Mahama Ayariga and his lawyers have filed a civil suit in court to dismiss the charges against him, and it's coming on today.
Okay, let me pen that down because I've got a question. You're not appearing yourself, but you can go ahead and file.
You are civil
because it's still today is still a Tuesday.
It's civil.
Parliament is so it's different from a criminal matter.
Why is civil? So you can. I mean, it's a civil matter.
Isn't it the same court? Isn't it still the same court?
It's the same court. Yeah,
yes.
but it's a civil matter.
Isn't Parliament still sitting?
You just what you need to do is just to give somebody a power of attorney to represent you in court.
So the problem is
and to vindicate your rights.
The problem is the person going to court.
Now the person. So Mahama Ayariga says that look. Now even before the Mavi, then I hear that one of the charges again is that.
So that we don't forget about it.
One of the charges is that he transferred the vehicles without paying the appropriate charges on the vehicles.
Is it not the 636 issue?
No. That at the DVLA, he transferred ownership to a car dealer without paying.
Okay.
And then the question that begs the answer is, what did the DVLA authorities do? Because when you clear a vehicle, it's a standing procedure. When you clear a vehicle tax-free, the tax-free is given to a person. And the person here means a natural person or an artificial person. Now, if that person no longer requires the vehicle for the use for which it was brought in, that vehicle is to be transferred. The transferee will have to pay duty for the car to be transferred to him. Because that tax waiver is not on the vehicle, but to the person. Okay, so the second person who is buying the vehicle is not a beneficiary of any regime of tax waiver, so he pays. Now, the DVLA will not transfer the vehicle until they see evidence of that payment. So
that is supposed to be the process.
Well, I'm just telling you, that is the process.
Okay.
That is the process. Now, so again, so what happened? I don't know. I'm just interrogating the matters,
and I appreciate that.
With the greatest respect to the special prosecutor.
Yeah.
I'm just interrogating the matter as I understand it. I might be wrong.
And we greatly appreciate that.
Okay.
Because subsequently the vehicles were sold off to someone else.
Yeah.
Okay, and you're telling us about the process if you want to sell your vehicle. And then the next person buying it will have to pay off.
Yes, because the tax was not for. And this is a general indication to everybody. If you buy a vehicle from a diplomatic mission, from a diplomat who comes back from outside mission with a vehicle for which tax was waived, or from an MP, you have to pay the tax. Or a vehicle was brought in for the purpose of undertaking a social project, and like companies come in and then we waive taxes on all the vehicles they are brought in. If you buy any of those vehicles after they have completed their work, you have to go and pay tax.
So this is our issue too.
Yeah.
Whether or not this was paid.
No, I'm not in the position.
But you said that we're interrogating, so that's what we're doing.
So
we're still interrogating.
We're walking a very fine, thin line, and I don't want, as a lawyer, if this matter finally goes to court, Mahama Ayariga will be entitled to raise a defense. You see,
Absolutely.
The good thing is that credible plausibility is the defense of Mahama Ayariga. Or if you want, raising doubt. Okay, in this matter. And so we should not be seen to be foreclosing all the...
Yeah, I appreciate that.
Yes.
My next question is, the monies that you're given to get the vehicles, are you physically given the money, or is the dealer who gets the money?
The dealer gets the money.
Directly from the bank?
Yes.
Is it in Ghana cedis or this is in dollars?
The cedi is in Ghana cedis. It's equivalent of United States dollars, but paid in Ghana cedis. So at any time that you are transferring the money to the dealer for outside purchase, it's going to be in there. So even if you buy a vehicle, like I've just given you two instances where in one instance I bought from Japan Motors, and then the other instance I bought from Sterling. Sterling, if they want to pay their suppliers, will show evidence that this is one of the vehicles that was sold to a member of parliament, which member of parliament was entitled to an equivalent of X amount of dollars, which is for the payment of the vehicles.
Okay.
So he can transfer that.
Okay, but is it you, Mr. Fuseni, who is transferring the money?
No, I just told you the dealer.
Okay. So the bank deals with the dealer would deal with whoever he's getting the vehicles from. Okay.
That's the procedure I understand.
Okay. All right. Mahama Ayariga is your friend?
Yes, he's my friend, my brother, and my colleague in
Parliament. Is he going to court today or not?
No, Mahama Ayariga, he wouldn't go to court today.
Why not? Members of Parliament, any different? The laws that you make in Parliament, do they affect yourselves as members of Parliament, or is just for the others, us, and not you?
We make laws for Ghana. And everybody in Ghana, whether you're a Ghanaian or not, you have to comply with the laws of Ghana. And so, so
why is he not going to court?
And to be a member of Parliament, you must be a Ghanaian. So Mahama Ayariga definitely is bound by the law.
Can I ask you another? Has he been served, apart from this letter that the special prosecutor wrote to the speaker, has he been served with a court document asking him to appear in court today?
I'm not able to speak to that, but I know yesterday I had a brief meeting with him in the presence of the minority leader. I must confess that Mahama Ayariga raises interesting legal matters. People have different opinions. I do have a different opinion, but I share. I mean, I sympathize with his position. Probably I would not have done it that way. But he will not go to court. He intends to raise the matter on the floor of the House, and then we'll see what happens.
How does that work? Has this happened before, this specific way that this is turning out to be?
Again, so we come back to the Dana Budapi matter. It didn't happen the way that is happening now. Because none of the earlier persons and references made to Sakande, who was member of Parliament for Boko, and Dan Abodakwe was member of Parliament for Anglo. Now, both did not raise the legal issue, the constitutional issue of immunities as being raised in a manner that is being raised by Ayariga. Now, but my understanding is that in the case of Dana Abodakwe, he raised the matter before the High Court, which was trying him.
So he appeared and then raised the
matter before the High Court, and the High Court granted him the permission to attend court only on Mondays. Okay,
so it wasn't the Speaker, and it wasn't the Attorney General.
The Speaker doesn't give.
But it wasn't the Attorney General in this case. In that case that you cite, it wasn't the Attorney General that said.
Attorney General has no capacity to waive attendance. To court.
But you get why I'm asking that.
I don't get it.
Okay.
Unless you tell me.
No, that's fine. It's okay. We can leave it there. Okay. But I'm sure the people following the line of questioning would get the point that I'm trying to make. So the interesting thing is the court that says, okay, you can come to court only on Mondays. That's in the case of Dana Abodakwe.
So that's why I say that, well, I would not have done it the way he has done it. But I respect the position he has taken. As a legal practitioner, as an accused person, I'll go to court and raise the jurisprudential issue. Because the Speaker has already written to the Special Prosecutor, telling the Special Prosecutor that, or informing him that Ayariga will be engaged in parliamentary duties, and that he will not be available to attend court on days that Parliament will be sitting. Now, the Constitution says that when the Speaker does put pen to paper and say those things will be conclusive. And you know, evidence degree, what conclusive evidence means.
But there was a response from the Special Prosecutor, wasn't there?
Well, I'm saying that that's conclusive. It's conclusive. The only thing is to argue on whether member of Parliament who is appearing as an accused person is caught by the provisions of the law, as stated in 118. But that's conclusive evidence. Okay? So it's not even for the special prosecutor to say that, well, I won't go by it. That's conclusive. So you go to court and say, look, I've invited Ayariga to come before me, and then the speaker has written to me to say that Ayariga will be engaged in parliamentary duties. Can you fix court date for Monday?
Isn't that also a bit of difference in terms of the processes? Because, and I want to make it very simple, and let's use you. The AG has a case against you, and so the court summons you. What business has the AG writing to the speaker to release you? Because I'm looking at it in the sense of, but this is no longer a matter of, this is courts now serving you.
Because you're a member of parliament. I mean, it is, I mean, to say that you can just walk to a member of parliament and invite him to court to appear before court is to assume that a member of parliament doesn't occupy any special place in the governance architecture of this country.
But
unless you're just
the rule of law, does the rule of law recognize the structures and where you belong?
I don't think that the rule of law does. That is why in the rule of law, procedure is very important. And so it says that a service on the member of parliament, if served on the clerk, constitute good service. Okay? So, and the rule of law requires that if the speaker releases the member of parliament, that member of parliament is bound to attend to whatever summons that has been. It's part of the rule of law. In fact, in Moshi and Bajina, it stated very clearly that rule of law is as important to substantive law as it is to procedure. You can't say that substantive law applies to everybody. And so, because there are different procedures applying to different persons on the same substantive law, those persons who enjoy certain privileges for which the procedure will have to change to accommodate those privileges are treated differently. You must also go follow those procedures. If you fail to follow the procedure, then you'll be violating the ethics of the rule of law. And so, it's just that...
So this is just following you...
To put it more generally, if a law says that something can be done, it is in doing that, if the law also provides the way that thing should be done, you must not only do what the law says you can do, but you must do it in the way the law says it should be done. Okay. Yes.
So this is just following
the rule of law. And so for me, let's wait and see.
So let me ask you, because you're a lawyer. If a court summons you and you essentially refuse to go, that can...
You might be putting yourself in contempt unless you have justifiable grounds. For instance, if the court summons you unaware that Mama V is presently out of jurisdiction, it's not in the country. The court says, Mama V come to court on 4th of June, and Mama V is not there. The physical difference in time and space will make it impossible for you to attend court. So you wouldn't attend court, but that will not be a willful disobedience of the direct summons of the court. So you cannot be in contempt of court. You purge yourself of the contempt because you were not simply in, and so you could not have. The limitations, the physical limitations imposed on you by your absence makes it impossible.
So let me ask a practical question. So the case will be called. And I get it. But I'm just trying to say, what happens? Would your lawyers have to would they have to explain something? Because I know that you can be arrested for refusing to come when you've been invited. Correct?
You can be arrested, but again, there should be a procedure. You can't just, because I've not come to court, and I'm walking to Parliament, and then you find two BNI or policemen hiding behind a wall in Parliament House, and when I appear, they seize me and send me to court. No, we have moved past that. No. If you don't attend court, and the court is minded to believe or come to the conclusion that you have treated it with contempt, you have done so in willful disobedience to the sermons, the court then goes further to issue an arrest warrant.
Okay, would that respect where you are in terms of you are in Parliament, on your way, you know, all that?
No, that's for
privilege.
That's for service. That when you are on your way to Parliament,
you can't be served.
You can't be served.
Okay, but you can be arrested
with a process. You can't be served with a process.
No, please explain.
You can't be served with a process, and then when you come to the next one, he says you cannot be your duties, any activity that interferes.
Please, what are you quoting?
The Constitution.
Okay. Is it 117?
What? That gamut. There's a whole privilege. Just go to that, the gamut of privileges, immunities, and all those things. So you are immune from arrest. Which arrest would interfere with the performance of your duties as a member of Parliament.
So how do you answer to the courts then? I mean, you can't be arrested even when you have refused to show up in court when you have been invited.
So that is why there's a procedure. Again, so we come back to the procedure. So if a member of Parliament is to appear before a court of competent jurisdiction for an offense for which he is said to have committed, the procedure is that you inform Parliament, you inform the Speaker of the need for that person to appear before the court. And the Speaker will so release that person to come to court.
Can I ask my next question?
Yes.
Do you know if the Speaker has released Mr. Ayariga?
I know the Speaker has written to inform the Special Prosecutor that Ayariga will be released. And let me state, even before I get to the, I get the impression that Ayariga is refusing to go to court. No, even the letter written by Ayariga doesn't say he won't go to court. It says he's available to go to court on Mondays. He says that. And so the Speaker is saying, yes, we have received your letter. We are mandated to inform you that Parliament is in session, that Ayariga is even a member of the ECOWAS Parliament. We will release Ayariga to attend court on Mondays of every week, such that his attendance to court will not interfere with his duties as a member of Parliament.
Was this after Mr. Ayariga's 2nd June letter?
No, it was even before Mr. Ayariga's 2nd June letter. Mr. Ayariga's letter did not refer to Speaker's letter, but probably Mr. Ayariga did not even know that the Speaker had written a letter. Yeah.
Okay. So Speaker has agreed to release him, but not on days that Parliament is sitting,
because
correct?
The Speaker has come to the conclusion that if Ayariga is to attend Parliament on days that Parliament is sitting, it could well interfere into his duties. That's the Speaker's interpretation of the Constitution.
Okay, but after the Speaker's letter, the Special Prosecutor wrote to say they needed Mr. Ayariga today, 4th of June, correct?
I'm not aware of that. I'm not aware of that.
You're not aware of the Special Prosecutor's letter?
A response to the Special Prosecutor's letter?
No.
The Speaker's letter?
No. The Special Prosecutor writing to the Speaker, and I don't know which letter came first.
No, okay, so these are the chronological of events that I understand.
Okay.
The Special Prosecutor wrote to the Speaker to release Mahama Ayariga to attend court today, 4th June, to answer charges preferred against him in the Financial Crimes Division of the High Court, Accra.
Okay. This will be a letter dated 23rd May.
You don't have the date?
Yes.
I don't have the date.
Okay.
Now, so the Speaker receives the letter and replies to the letter, saying that yes, we have received, acknowledging receipt of the letter, but indicating that he's constrained to release Ayariga to appear before court on Tuesday because in his view, that would interfere with the performance of the duties of Ayariga as a member of parliament.
Okay.
And that, in his respectful view, the special prosecutor could fix the case for hearing on a day that would otherwise not interfere with Ayariga's performance, mandatory performance of his duties as an MP.
Okay.
And in the view of the speaker, this day is only Monday, or days that parliament is not sitting.
Okay.
Now, and it's not a public holiday. Now, so he sends the letter. I'm not aware that the speaker has replied to that letter.
As in the special prosecutor has replied to that?
The special prosecutor has replied to it.
So the next one that we will see is Mr. Ayariga's
The next one that we also was
to
Mr. Ayariga's letter.
To that letter.
At that time that the speaker was writing the letter, I am aware that Ayariga was at Abuja attending ECOWAS Parliament.
Okay.
So Ayariga too had been copied by Mr. Special Prosecutor.
What was his...
The letter that he had written to the speaker. So we all got up yesterday and saw Ayariga's response.
Was it necessary?
Well, that's a matter of opinion. An opinion like noses, everybody has. I would not have replied to him. I would have waited for the speaker's letter. Because, you know, because you are an accused person, the morality of the issue weighs heavily on you. Because you are an accused person. And people might interpret your actions as running away from the long arms of the law or frustrating the cause of justice. He has a good point. He has good points. Probably if I were not in Parliament, this would have been a matter I would have loved to offer my services as a lawyer.
Oh, you'd have been on his legal team.
I would have been even for pro bono, just to understand the basis of the charges. Now, because it's quite novel. In the past, where people have been accused of not paying the required taxes, they don't send them to court.
But if you look at the beginning of this issue, probably wouldn't have gotten here.
Well,
because part of the special prosecutor's duties really is to, you know, reach amicable.
Well, so did we explore?
And if it's you paying back the money and just take
the possibility?
So I have a question. Did Mr. Ayariga present himself to that opportunity?
Did we even explore the possibility?
From where you sit, did he allow himself?
I know from where I sit that when all these matters came up, Ayariga decided to revert to the status quo ante, the position he was in before he bought the vehicle.
Which is?
Which is return the waiver.
But shouldn't, because, you know, one of the things I was alluding to, the special prosecutor, is plea bargaining.
No. Plea bargaining is when you want, when your status has changed, you still want to be within that status, but right a perceived wrong.
But on your own, because
the plea
of
bargaining,
because the
plea
special
bargaining is admitting culpability. It's admitting I'm culpable.
Okay, so what's the difference between that and you trying to reverse and?
So what is freedom of action? Okay, I decide to buy a Camry with a loan. Then while processing my documents, including the waiver, I come to the conclusion that, oh, even Camry is not the fashion, is not what will serve my purpose. I probably will want to buy a Mitsubishi. Now, so I cancel I cancel all the processes.
But in this case, it didn't happen that way. It was only after the special prosecutor raised issues. That's when he decided to, okay, let me restore, let me go back to how it was, correct?
Well, at what point do you invoke your right to cancel a process?
No, so my point is,
that when
what's the difference? What's the difference? That's why I asked, what's the difference between that and plea bargaining?
No, plea bargaining is when you play bargaining.
But if you haven't done anything, you know, trying to restore, go back and get rid of the vehicles so that you're not. I mean, the whole thing is a bit murky in that space.
It's not murky. It shows that if you put your mind to it, you will understand clearly that
isn't this a lawyer trying to be smart?
Well, is a lawyer trying to be smart? What are lawyers for? Have you ever seen a dumb lawyer? No, so you see, if you do or undertake a venture and come to the conclusion that that venture or that journey or that activity that you are embarking on probably will not secure you the benefits that you had earlier anticipated. At what point do you say that I'm stopped, I'm prevented from revert?
All right. Okay, so this is where we are with this matter.
Yeah,
okay, just the last thing before we wrap up. You sit on one of the committees that this possible church regulation issue has come to. It's a combination of the subsidiary legislative committee and the youth and sports, or the youth committee. Have you started the deliberations, the joint committee?
No. I'm not aware that they have started deliberations. But, Mama V, what is there to regulate?
It started from Parliament. It started on the floor.
I just think that the call for the MP to regulate churches was misconceived and misdirected.
Okay. We'll see that reflected in your recommendations.
Because there are already regulations. I mean, you regulate what? The form of worship.
You are the lawmakers.
So that's why it's misconceived. What are you regulating? That because we fast and because it's part of the Muslim's duty. And first of all, I say it's misdirected because he's talking about churches. So I'm a Muslim, and the Quran enjoins us to fast 30 days. And I have ulcer, but I have faith that God will intervene even with my situation if I fast. I consult my imam, and my imam says, oh, well, if you think you can fast, then I fast. Then it develops complications. They should regulate me to say that because I have ulcer, I shouldn't fast. Are you now going to import human laws to deal with the laws of nature?
How about the other excesses that we've seen? Some pastors directing.
I'm a Jehovah's Witness, and I say, well, my faith doesn't allow us to take blood transfusion. And say, well, your faith cannot override the laws of Ghana. So we must regulate you. All Jehovah's Witnesses must allow for blood transfusion. What are you regulating? Oh, people should not speak in tongues. What are you regulating? Because if it is churches or some churches engage in violations or in activities that are cruel and inhuman, there are already laws that deal with that. There are already laws.
So you're coming from that point of view?
The church in Kenya, or is it Uganda, that got its members to chew grass, did you hear that they sent them to court? Or that got members to lie on the ground and the pastor was walking over them with the aim of healing them? Did you hear anybody taking them to court?
Are there laws?
Religion is the opium of the masses. Karl Marx said that long ago. And freedom of conscience is said that there's no rationality in religion. It's not logic. So we deal with the aspects of religion that touch crime. In fact, in the olden days, before now, you remember the case of Galileo When he ventured to posit that it is rather the sun, that it is rather the earth that moves around the sun, and not the other way around, he was hanged for blasphemy. He was not even the law, but he was seeking to change the thinking of the dominant church.
I've got a question. So the other things that we see happening in some of the cases where we see some prophets ask members to do things that are unreasonable, at least to the observer, do we have enough laws to deal with those things?
If you say unreasonable, I've already told you that religion doesn't admit to reason. The religion doesn't admit to reason.
Don't some of the things?
So if you put
say
oil,
some of the things are criminal?
Good are potentially criminal. You look at the laws that criminalize those conducts, and you punish them in accordance with the law.
So I heard a lawyer say, if you ask someone to sow a seed, and that they will make 1,000 times more from the seed that they've sown, that's a fraud. But that's not one that the laws we have presently can easily capture.
How can that be fraud?
We can't get you under those laws. That's why we need the regulations.
How can that be fraud?
Well, you tell me.
But
you are the lawyer.
His mind is limited to what he knows, that no seed can generate. My religion tells me that on the day of Lilat Qadar, the night of power, that day is better than 1,000 nights. And I believe in it.
What does that mean?
You know 1,000 nights? 80-something years. And I believe and pray that I chance on that day, that night, that is more than 1,000 nights.
This is not logic. Okay.
Yeah.
All right. So is it that you're how many? You're 25 on that committee. How many of your colleagues think like this?
That's the beauty.
I'm just wondering how far this whole.
That is the beauty. That's the beauty of democracy, also. That's the beauty of democracy. Okay. That you express your view. A platform is given. So the platform was given to a member of parliament from Infansipim or Infamsiwa. And then he said what he said. So they are equal platforms. So when they report it, so everybody will see what he.
Okay.
But religion is not a rational venture. It's religion. That's why you don't ask why. Why? The whys will end at a point in religion. And then you will transpose yourself into the spiritual realm. And you seek comfort there. Okay? So that is what religion does. Absence of religion is anarchy, chaos. The values, moral values, norms, and ethics of religion is what is keeping the world sane.
So that will be the member of parliament for Infantaman then who raised the issue on the floor. Okay. Well, thank you very much for this perspective to this regulating churches, possible regulation. But you haven't had your first meeting. When do you anticipate that first meeting will come?
Well, I'm not the chairman, so I'm just waiting.
Oh, you are ranking.
Yeah. No. That's for subsidiary. You are not ranking. You are chairman. The subsidiary legislation. It is the opposition that chairs. Subsidiary and then public accounts.
Oh, so this is Mahama Ayariga's committee then?
Mahama Ayariga has been moved. It's now Dominic Ayine.
Oh, okay.
Yes.
All right.
Yeah.
Okay. Okay, so we'll see what happens with this. But thank you very much for your time this morning.
You're welcome.
I've loved every bit of this. Stay with us.